Todd Blanche, Trump defense lawyer. The Access Hollywood tape was released October 7th, 2016, a month before the election. The tape itself was from 2005, 11 years earlier. And as you heard from witnesses, this was an extremely personal event for President Trump. Nobody, and again, I'm just going to state the obvious, nobody wants their family to be subjected to that sort of thing. But the government wants you to believe that the release of that tape from 2005 was so catastrophic to the campaign that it provided a motive for President Trump to do something criminal. Again, this is Trump's defense counsel, quote, "But there is no evidence of that. President Trump did not react to the Access Hollywood tape in any way the government is suggesting. You heard the politicians reacted negatively to the Access Hollywood tape. They didn't testify. You heard that there was even talk about something consequential for President Trump, who was a Republican nominee. But none of that happened. None of that is true. You heard that President Trump and his campaign got ready for the debate, responded to the allegations, and continued campaigning. So there were a couple days of frustration and consternation, but that happens all the time in campaigns, and we know that. The Access Hollywood tape is being set up in this trial to be something that it is not. It was one of many stressful stories and issues that came up during the 2016 campaign. It was not a doomsday event. President Trump, as you saw, addressed it in a video that was addressed to the release to the American public. He addressed it in a debate a couple days later. He never thought it was going to cost him to lose the campaign. And indeed, it didn't. It was not a doomsday event. That was from Trump defense counsel Todd Blanche today in his summation to the jury, claiming that the Access Hollywood tape was no big deal. And obviously, you can argue about whether or not it makes sense for Trump's defense to try to make this claim that there was no new sense of urgency around Trump's various creepy sex scandals in October 2016, right before the election, right after that tape came out. The strategic importance of making this claim is not, at least to me, particularly obvious on its face. But this is a factual claim, right, from the Trump defense. The factual record about whether or not that tape was a big deal, that is an empirically observable thing. That is a thing we can check. Did it matter at the time? We were all alive and sentient when it happened. We can remember. We can check.
Trump tape bombshell. Donald Trump caught on a hot mic months after marrying Melania, making vulgar comments about groping women, saying when you're a star, they let you do it.
Notice the hurricane graphic at the very beginning of that. Going away. No, it's this thing. When the Access Hollywood tape came out just a month before the 2016 election, it did knock hurricane news out of the news cycle. It was what NBC News' Lester Holt described at the time as a bombshell. Not only did Trump's comments about grabbing straight for women's genitals make front page news across the country, the news really did, in real life, lead to an avalanche of Republicans calling for Trump to drop out of the race. This is the New York Times. Lewd Donald Trump tape is a breaking point for many in the GOP. This is the Washington Post. 36 Republicans have now called for Donald Trump to drop out. Here's the local view from swing state Michigan. State Republican leader Ronna Romney McDaniel says Trump's talk about women is disgusting. This was the headline in Politico. Republican women are done with Trump. That all happened not that long ago in our living memory. Today, in closing arguments, Trump's defense tried to argue that the Access Hollywood tape was just a normal day on the campaign trail with no real consequences, trying to tell the jury that even though the timing of the evidence makes it look like Trump's side suddenly got motivated to quash the Stormy Daniels story days after the tape, well, that can't really be right because Trump had no reason to worry about the impact of that tape. It had no impact. Why make an argument like that is so easily disprovable, even by people's own living memories, right? All these jurors, these jurors are not junior high school students. They were all old enough in 2016 to have lived through it and to remember it. Even if they did forget living through it, in her testimony in court this month, Hope Hicks, the Trump campaign press secretary when the tape came out, described the release of the Access Hollywood tape by saying this. She said, quote, "I had a good sense to believe this was going to be a massive story." Quote, "I think there was a consensus among all of us that the tape was damaging, and that this was a crisis. Hicks also went on to describe how it pushed hurricane news out of the news, making this claim to the jury, Nicole, that what you lived through and what you must remember about this moment didn't happen.
Yeah, and I think that's why the prosecution has reason to feel decently confident that they've made a strong case on the underlying piece, right? And if you're a student of Trump's social media posts, you can smell his panic. They're not worth platforming on a program like this. But I think that that Blanche's need to address Access Hollywood speaks to the strength of the part of the prosecution case that we don't talk about quite as much. You know, we get lost in the exhibits and the cross and the direct. But what they've established, obviously in a way that made Todd Blanche nervous enough to say something on its face ludicrous, because, again, the only time this jury has seen Trump talk was when he was saying the things that Lester was covering there, that this is going to poison me in the minds of women. And the thing that no one will ever know, the piece that's lost to history because they pay Stormy Daniels to stay quiet ahead of the 2016 election, is whether that would have tipped it over, right? Whether Access Hollywood plus Stormy would have done what Trump was afraid it would do. Yeah. The other piece, I quoted it already, is Steinglass says in his summation today, the sex happens in 2006. Stormy doesn't get a dime until 2 weeks before Election Day.
Right. They're not interested in paying to make this go away until Access Hollywood happens and the election's about to happen, and they know that that's the fatal moment.
Right. And I mean, the other piece about the timeline and what the jury saw before Michael Cohen ever was introduced to the jury as a walking, talking human being who kind of didn't blow, right? He was demeaned by almost every witness. I mean, there was a side swipe from Pecker who said he couldn't do anything. He got a very short leash. There was Hope Hicks saying he wouldn't do anything without getting credit. Before he takes the stand, what you know is that he was instrumental. He helped Hope Hicks write the denial when the Access Hollywood tape comes out.
Right, because they needed to, because it was catastrophic for them. Yes. All right.
Donald Trump's defense team trying to find ways to create reasonable doubt. Their lead attorney, Todd Blanche, boiled it down as this: Trump's innocent. He didn't commit any crimes, and the DA hasn't met their burden of proof, period. And that's almost boilerplate. You could get that out of the AI, ChatGPT, but they did go into more details, arguing nothing happened. But if something did happen, Michael Cohen did it, that the hush money scheme was basically done somehow without Trump's knowledge, or at least with the key criminal intent, and whatever might have happened. Also, the legal defense here, they argued it's not against the law. We've shown you that over the course of the trial, and that was, again, what they were trying to push today. It was about 3 hours that the defense went. We should note that is already less than the prosecution. And at times it was scattered. The New York Times reported Blanche used sports metaphors in the top 10 list to push for Trump's innocence and tried to undercut the falsified business records by simply asserting, quote, there is no falsification of business records, period. Now, I can tell you right there, that is what is called conclusory, which is a bad thing in the law. You don't want to just say words or proclaim innocence. That's not even technically much of an argument, although it's within the rules of what they can say. What you need to give a jury here at the ending, if you're the defense, are pieces of evidence, testimony, or questions, which might not be as sturdy as evidence, that they might hold on to that create this reasonable doubt that we talk about, right? So Blanche also did some of that. They talk about this catch and kill scheme, and he argued, this is an argument, it may not be 100% true, there was actually nothing unusual about that whole sordid practice. Now, this case isn't about an alleged election crime, and multiple witnesses said Trump was concerned about this for campaign reasons, the Access Hollywood tape, all that stuff you probably remember. So here's what the Trump lawyer said today. The tape here is being set up in this trial to be something that it's not. It wasn't a referendum on views on Trump. It's not a referendum on the ballot box. Trump addressed the tape, he said, in a video that was released to the public. He addressed it in a debate a couple days later. He never thought it was going to cost him the campaign. It was not a doomsday event, as you see there. Now, that is a type of interpretation. That is fair game. We heard from witnesses, including around Donald Trump, including Hope Hicks and Michael Cohen, that this was a kind of doomsday event, that they were literally talking at the RNC about kicking him off the ballot. But this is, again, where the reasonable doubt comes in. If you can get one or two jurors who might not be as versed in politics as some people to think, I don't know, maybe it wasn't a big deal. It was a long time ago. And didn't he become president anyway? They might have reasonable doubt as to whether this was a campaign motivation. Then you have the star witness, Michael Cohen. I mentioned this early in the broadcast. There he was walking around. They tried to undermine everything Cohen said and his credibility. They told jurors that he was repeatedly lying under oath. He lies to his family. At one point, they argued he's like the MVP of liars. He lied to you, make no mistake. And if you've heard about GOATs in sports or music, that is for the acronym greatest of all time, well, they slipped in another letter. Michael Cohen is the GLOAT, Trump's lawyer claimed. He's literally the greatest liar of all time. A twist on the Michael Jordan reference. Now, I talked about chutzpah, a reference from the prosecutors earlier this hour. Whether GLOAT is a great pop culture reference or not, that's not the question. Question is, do those kind of things, which are frankly gimmicks, do they resonate with one or two jurors who, when they're debating this in the days ahead, say, hey, isn't he the GLOAT? Isn't he a liar? Don't we all agree on that? And so these are the things they're trying to do to poke holes. The defense also went after Cohen for recording his own former boss. You remember that evidence.
I need to open up a company for the transfer of all of that info regarding our friend David. I spoke to Alan about it when it comes time for the financing, which will be...
Listen, what financing?
We'll have to pay you. So
Don't pay the kid.
No.
Now, that is just a damning piece of evidence. It was damning when it came out. It was damning when different Trump people tried to spin it. It's been damning in this case. So what does it mean to have the defense try to deal with this in closing? What can they even really claim? I'm going to show you. Quote, Mr. Cohen told you he thought that President Trump was referring to green, which makes it more sinister. Green, cold, hard cash. That was Mr. Cohen lying to you, painting a picture that fits his narrative, not the truth. Now, here's the point there. They are trying to get the jury to get fixated or even confused about what that tape means. Because the point there isn't just the cash part, although that could make it worse if that is interpreted as Trump trying to hide this. Could make it worse. But the real point is they're trying to get people to think about anything other than what's on the tape, which is Trump knew about it at the time. Remember, if Michael Cohen went rogue and did all this stuff himself, maybe Trump didn't know, he was busy on the campaign trail. No, they were talking about it. It's on tape. So what I'm telling you is not that this is the most accurate or fair rendering, but this is the defense. The defendant is entitled to their best legal defense, and they're trying to poke holes and say, oh, remember the tape, maybe it was manipulated, or maybe the cash thing was sinister, or maybe Cohen spun it. And it's like, forget spinning it. The tape is a valid, real piece of evidence that shows Trump knew then. But we won't be in with the jury when they're talking about this. Who knows what things they'll remember about it. As for the compensation, the lawyers say Cohen talked to every reporter that he could, pushing the fact that he was going to be the attorney to Mr. Trump and the payments were compensation to him, period, meaning he used to lie about it. Quote, he's biased and motivated to tell you his story. It's not true. Now, there was another moment today that shows a kind of either lawlessness, desperation, whatever you want to call it. Trump's lawyers did something that not only is not allowed in this kind of summation, but actually they had been personally, specifically warned not to do by this judge. And that is try to blend two separate things. A lot of people are watching this case thinking, what if Trump ends up in jail? And as a citizen and a news viewer, you are free to think about that and ask about that. But in the fairness of our system, that is not supposed to be used before the jury, and it's certainly not supposed to be used by Trump's lawyers to kind of scare the jury and say, oh, no, he could go to jail forever. How unfair. So that's not allowed. In other words, the jury's only supposed to decide what happened. Did he do it? Not what the punishment would be, which in this case, in New York, would be meted out by the judge. And yet there they went, Trump's lawyer today, saying you cannot send someone to prison based on the words of Michael Cohen, the objection right out of the prosecutor's mouth. And that was a violation. So what does that mean? Well, they discussed it. The lawyers discussed it with the judge, and then the judge admonished and rebuked Trump's lawyer, saying it was outrageous. Someone who's been a prosecutor, as long as you have a defense attorney, as long as you have, referring to all of his history, it's simply not allowed. It's hard for me to imagine how that was accidental in any way. And I can tell you, because we were watching in court today, the judge later told the jury, not only is that stricken from the record, but you cannot discuss that in your deliberations. He basically told the jury that was a no-no, Trump lawyers were wrong, and you're only supposed to find the facts. And then he even said out loud, and this is important, especially with fairness, he said to the jury, this is a case where even a potential conviction might not result in prison. In other words, if you're thinking as a juror that it's so unfair that the former president might go to prison, stop thinking about that, it's not allowed, and don't worry about it because he might not go to prison, but it's ultimately up to the judge. Now, the defense just has to find, as I've told you, one juror who has this reasonable doubt. This is the be-all, end-all.
Adam, again, to go back to the morning, which was a long time ago for all of us, and Todd Blanche's defense argument, because we're going to cover a lot of prosecution. One of the things I say about the prosecution is that the evidence that the prosecution has is very familiar to our audience, because that's been available to us for a very long time. We've been presenting most of it here for a very long time. What we always were sitting around waiting for is, what's the defense? What is the defense of this? And so now that we heard today's most cogent presentation of the Trump defense in this case, Todd Blanche kept coming back to reasonable doubt, reasonable doubt, reasonable doubt. He wasn't going for an innocent. He wasn't going for that. He understood, look, Donald Trump cannot be defended as an innocent person. Donald Trump did stuff within this story that you're not going to like. But did Todd Blanche wedge in enough reasonable doubt for a jury to cling to?
I think the answer to that question helps explain why Josh Steinglass went so long. I think the strongest part of Blanche's presentation was in the morning when he stuck to the law. There was this one part where he was talking about the intent to defraud, and there's one line: there's no other way to characterize an invoice from a lawyer to President Trump than to call it a legal expense. The government has criminalized that, has said that was a crime. What the payroll administrator did, that's absurd. It's not a crime. And he said later, he talked about the mechanics of how these ledger entries were entered. And he pointed out it was a drop-down menu. And presumably from the drop-down menu, there isn't hush money to porn star. So when he resigned himself to the law, that was the strongest part of his defense summation. And I think where things started to go off, and I think where the Steinglass was very effective, is where Blanche started coming along with his rehearsed one-liners, calling Cohen the MVP of lies, the gloat, greatest liar of all time, the living embodiment of reasonable doubt. But he would do that in this kind of scattershot way. And I'm a little biased toward this moment here of what I thought was effective, because I predicted this moment on this show last week, where I said that it seems the defense is pushing this internal inconsistency, this logical inconsistency that's going to be called out by the prosecution, and Steinglass did.
Yes.
And the moment was when tarring Cohen as a thief, and that the defense wanted to have it both ways, in the word of the prosecution. And here's what Steinglass said: but in any event, none of this matters, because it's not a defense to the false business records charge that one of the co-conspirators is also guilty of stealing from another. And I will tell you something else that was kind of funny. And Steinglass actually laughed at that moment.
He presented this very well.
Yes.
Yeah.
And said, I don't know if someone caught this during the summation, but Mr. Blanche said, well, he stole $60,000, right? Because it was grossed up. But so that means that the defense is trying to have it both ways. They can call him a thief or claim this wasn't really a reimbursement, but not both.
Right. It's that internal conflict in the defense theories, Andrew, that I've been watching for, which is it's not a reimbursement. That's his paycheck. He earned his paycheck by doing legal work. And as Lisa points out, the DA said today, Michael Cohen spent less time doing legal work for that money than he spent in cross-examination in this courtroom. But so it's not a reimbursement, it's a paycheck. That's one defense argument. And then over here is the other defense argument that in this reimbursement formula, Michael Cohen lied about how much he should be reimbursed. And so he was reimbursed too much. We get to call him a thief because it's reimbursement. But wait a minute, you just called it a paycheck. And now you're saying he's a thief because it's reimbursement.
So in Todd's defense, I do not think it was a good summation just to be clear.
Was there a way of him solve? See, because I just sat there waiting for him to solve that problem in the case. Was there a way for him to solve it?
So first, it is not uncommon for defense lawyers to have very inconsistent arguments and facts, and because you're only trying to appeal just something to one juror, and you don't know what that one thing will be. So that you are presenting a whole range of things, and unlike sort of an appeal brief where you pick your best, suit and go with that, you really do try to present as much as you can and hope something sticks without saying something ridiculous.
Yeah.
He did. I mean, there were a few things where he shouldn't have gone there, where I'm pretty sure it's his client who insisted on it. But the reason I thought there was a real problem and the gift of Todd Blanche to this case and to Josh Steinglass was a little bit like the gift of Costello to Josh Steinglass, which is there is what Todd Blanche addressed and the huge problems with what he did not address. As you've pointed out, nothing in any way cogent about Exhibits 35 and 36, the handwritten notes by Weisselberg.
$130,000.
I mean,
never explained.
Never. I mean,
handwritten by Alan Weisselberg.
Those everyone knew. We've been sitting here. We've talked about them over and over again. You have to have a theory. If you do not have a theory, your client better be pleading guilty. I mean, you have to have some theory. There was no discussion of Hope Hicks about any of the damaging testimony. Just to use her for some embroidery, but not to deal with the substance. A second problem. David Pecker, again, not dealing with the damaging information. Nothing was said about that. To then say about the Access Hollywood tape, the only thing you're going to say about it is it wasn't a big deal. I mean, again, you have to come up with a better argument or just not address it. So Josh Steinglass was just given all of these gifts because all of that proved nothing was said. And so that is, I mean, I kept on thinking Susan Neckles, who I keep on sort of praising, had to be sitting there dying because
she was physically as far away as she could be. She wasn't just at the end of the regular counsel table. She moved over to where the junior lawyers are to get even farther away today.
And she is the most experienced defense lawyer in that room, other than maybe Susan Hoffinger, who is now in the prosecution side. And you just can't give that closing argument as a defense lawyer. You have to come up with something. And, I'm not sure what I would say about Exhibit 35 and 36, but you have to bring it up. And look, you have to at least say Donald Trump is not on this. You do not know what they said to him or did not say to him. You don't know if Michael Cohen said, don't worry, I've already talked to Donald Trump about it, so you, Alan Weisselberg, don't have to. You have to say something about it to help explain it because you know that they're going to jump all over it. So to me, it's so hard to give them high marks because of what wasn't addressed.
Alex, those are some of just the moments that stood out to me, both as outstanding questions, but also as big points in the summations. What stood out to you?
Many things. The first I will tell you is having gone to court today for the first time and hearing the voices of the lawyers was actually something. We obviously don't have audio of this trial, but hearing Todd Blanche, who had a scattershot defense, a scattershot closing arguments. He does not vocally command the room. He does not speak with great authority.
He looks like a tough guy, but he talks like Jared. He talks like Jared Kushner.
And it was notable that when he finally finished his argument, he sat down and he's sitting right next to Donald Trump, next to him, Rachel. And Trump is looking that way, and Blanche is looking this way, right? That's not the body language.
He sits down at the end of his summation, and they both...
And Trump is looking that way, and Blanche is looking this way. That is not the body language of someone who's necessarily happy with the job their lawyer has done. And remember that at the end of Blanche's closing argument, there was a lot of back and forth with Judge Merchan about Todd Blanche's, plea to the jury not to send Donald Trump to jail. That was something that was stricken from the record. There was a kind of a whole kerfuffle. So that was not great for Todd Blanche, in addition to a series of fairly wild assertions, some of which you pointed out One of my favorite ones was the excuse that there was no other way to categorize an invoice from a lawyer to the president than other than a legal expense. It was a drop-down menu. It was the only choice that they had at the Trump organization. That's all they could do, which clerically may make a lot of sense. Legally, I'm not sure. Their assertion that every campaign is a conspiracy here in the United States, Rachel, something I did not know. It's a group of people working together to help someone win. All campaigns are conspiracies. Tell the Biden campaign. The Access Hollywood thing was no big deal. Quote, this stuff happens all the time in campaigns. It's not a doomsday event. Sure felt like it to those of us watching on the outside. And then, of course, catch and kill is business as usual. This is not a crime. This is what happens in the media. And the National Enquirer, as you pointed out, is really just a zine. Nobody really reads the thing. It has no effect on an election. The idea that
every grocery store.
I mean, who reads it?
These sophisticated men. It would be preposterous for them to think the National Enquirer would have an effect on the world. That's why he's the guy who owns the company that runs the National Enquirer. He knows it's pointless.
Which is in every grocery store, everywhere you go across America, too. I mean, I was also struck, because this is my first time sitting in the overflow room as well, by the voices. And Judge Merchan, who everybody who's gone to the courtroom has described as very calm, he has a very soothing voice, I found. Even when he was telling Todd Blanche that he was outrageous, and when he suggested that the jury cannot find Trump guilty and send him to prison, which is, of course, way out of the bounds of what you're supposed to do as a lawyer, he was very calm. It was a little escalated, but he was quite calm. What struck me, not a lawyer, we'll leave that to you, Laurie, was kind of the storytelling. You've been talking about this over the last hour of the kind of, and the contrast between that. In many ways, it reminded me a little bit of like Trump versus the Democrats and how they communicate about things. Because the Todd Blanche's closing was very Trumpy, in my view. I mean, as you said, Alex, it was basically like, everything you think is wrong is totally normal. Yeah. Every election is a conspiracy. Everybody's working with media to pay money to people who have bad stories about the candidates. Everybody is doing this. This is just common. He even said, retainer is just a word, right? These are, it's just, and so
it's a drop-down menu.
It's a drop-down. So you wonder, and to me, it reminded me of Crooked Joe and, or Crooked Joe and Crooked Hillary, and Corrupt Joe, right? This kind of message of like, everybody's bad, everybody's corrupt. We all do this stuff. Now, whether or not that's going to work with a jury of 12 men and women, that's a question none of us know the answer to. On the other side, you had Josh Steinglass, who was like, I want to be in a study group with him, first of all. But it was very methodical. It was very meticulous. It was maybe too detailed, as Ari said before. There were moments where sitting in there, you were kind of zoning in.
You were
and
like,
zoning
is
out.
time a dimension? Are we still there?
Were there moments when he looked essentially at his prepared material and like, let's skip this part? You guys are getting the point. I'm losing you.
It felt like an hour 4.5.
But he did say earlier in the day that it was going to be 4 to 4.5 hours, right? And it was, of course, longer.
He lied. Well, it wasn't that much longer. It was 4 hours and 40 minutes.
4 hours and 40 minutes. But he was on the top end of that. I think we can say.
On a lighter note, tell them about when he said it's only a third done.
Oh, wait.
That's when I fainted, so I don't remember.
There was actually one of the interesting things also sitting in the room with so many legal experts was that when he said 4 to 4.5 hours, there was an audible gasp in the room of the length of that, of how long that would be. Now, they can be as long as you want in state court, so he has every right to do that. And then when he said, I'm a third of the way through, there was another, like, in the room
when he had already been going for hours.
When he'd been going for 2 hours at that point in time.
In terms of, Joy, talking about some of the points that these guys raised, I'm kind of stuck on the drop-down menu. So the drop-down menu was like, let me just tell me.
Sure.
It's hard to actually tell.
I was obsessed with the
I looked at
the
this part of the transcript, and it's sort of hard to tell from the transcript. So my impression from it, correct me if I'm wrong, because you guys were there to hear it, was that they were saying, effectively, yes, we may have booked these expenses at the Trump organization in a way that was technically false, but we had no choice because the software was designed in such a way that it made us falsify.
Our hands were tied.
Yes,
sure, conveniently.
Okay.
You know, I think the line that, you know, and so this was all happening toward the end, halfway through my show, they were finishing. So we just kept on reading whatever was coming through the Google Doc that we're so blessed to have. And we're sort of reading it in real time with the wonderful Katie Fang there. And the line that really stood out to me from Joshua Steinglass, who seems to have done a fantastic job. This was a really strong prosecution team. I think we can all agree that they each were really good at the storytelling piece. But Joshua Steinglass says, use your common sense. Mm-hmm. The drop-down menu thing is a use your common sense moment because the challenge, and even the day I was there, this was a challenge I had with Todd Blanche, is that Todd Blanche is kind of all over the place, and he's kind of Muppety, and he's kind of Muppetizing all over the place, and he doesn't seem to be even satisfying Donald Trump with his lack of storytelling ability.
What does Muppetizing mean?
Meaning he's just flailing around like Kermit the Frog. Like I can almost see his string arms going as he's talking. He's string arming. You know, it doesn't make sense. And it's very all over the place. But the prosecution, to me, has done a good job overall in all of these days of this trial of telling you a very simple story. Mm-hmm. Does it make sense to you, I think Mr. Steinglass was saying, that cheap, micromanaging Donald Trump would pay Michael Cohen, who the other side says is a lying liar and a horrible person, just give him $35,000 because there's a drop-down menu that says the only way he can explain that is that it's a reimbursement. Say it's an NDA, but not really know any of that is happening and be completely unaware of it during a campaign to become president of the United States. That he knew nothing about it, even though he's a micromanager and cheap, and he gave away all that money. And then they've never really explained that other exhibit, which I think is the most damning exhibit, which is the handwritten notes. Yes. How do you explain why those pieces of those numbers are on that paper?
There's no defense explanation for those papers.
And they've never tried. And the thing that's been sort of shocking to me, and I know Todd Blanche is an experienced prosecutor, but as a defense attorney, they never even tried to explain that.
There was also all these documents. I mean, there's this PowerPoint that was very poorly put together. Not that I'm a PowerPoint expert, but they had handwritten notes and a lot of these PowerPoint slides.
The defense did?
Which they didn't explain. I mean, they kind of flashed through, so you didn't see what was in each of them. But there were some of them that had a few handwritten notes on them as they went through the slides of the presentation. And he just skipped over them.
The jury to sort of digest them without walking them through
I think you're assuming that he was explaining each slide.
He wasn't.
And he was not.
There were exhibits placed for us to see.
For us to see.
The jury was not walked through them, which I don't think is a particularly effective defense strategy.
Well,
That's weird.
And I've never, obviously, you know, I've never gotten through. I want to be on a jury so badly, but for some reason, judges don't want me. But I've been on a grand jury, and I can say in that kind of a situation, it may feel over-explained what Mr. Steinglass did with 4 hours, but I found that even in that kind of a process, the more detail, the better. And so I think the advantage the prosecution is going to have is when they explain the law. Your feelings about Michael Cohen, even though they've now met Michael Cohen, he seemed perfectly reasonable on the stand, and he followed, but he was, you know, respectful to the judge. They're going to be on the judge's side. The judge is your therapist. That's his voice, right? So I think the challenge is that when you get all that detail, and then the judge explains the law, all that jury is going to do in that room is they're going to compare the details that they've gotten from both the two sides to the law. And I still cannot tell you what the defense is against the actual legal claims against Donald Trump. Because if the first witness, Mr. Pecker, which is the day I was there for one of the 2 days of Mr. Pecker, he admitted it was a scheme to impact the election. Michael Cohen is on tape and admitted it was a scheme to impact the election and went to jail for that scheme. There's been no explanation of how Donald Trump could have not known that and how it was not a scheme. So the problem is when they look at the law and they look at the facts, I don't know where the defense is going to. They just need somebody to nullify, and I don't know how they do that.
Yeah, well, I mean, as Ari was arguing before, it is a hung jury approach from the defense rather than an acquittal approach. So they just need to get somebody to get stuck on one piece of the evidence. As a legal matter, though, there was a really, really, really dramatic moment with both of you guys just mentioned right before lunch, where the judge, hold on, I just lost it.
Quote, conspiracy and a cover-up. Prosecutors today reminding the jury of the basic facts of this historic first-ever criminal trial of an American ex-president. As we come on the air, closing arguments are right now underway. In the people of the state of New York versus Donald J. Trump, we're getting live updates from inside the courtroom. We're going to do our best to watch them together and interrupt our conversations and bring you any and all significant moments as they're happening. Over the last few hours, prosecutor Joshua Steinglass has been going through the claims that were made by Trump's lawyers in their closing argument this morning. Steinglass, the prosecutor, pushed back against Trump's lawyer's claim from this morning that porn star Stormy Daniels was extorting Donald Trump. Prosecutors saying this, quote, extortion is not a defense to falsifying business records. And if you have any questions about that, you can ask the judge. After putting on the stand just two witnesses, one of whose credibility completely crumbled during cross-examination, Donald Trump's defense team today closed by arguing essentially that there was never any criminal conspiracy to conceal the hush money payments. Trump's attorney, Todd Blanche, also went after Michael Cohen aggressively and loudly, calling him the, quote, MVP of liars and the gloat, get it? Claiming he lied to the jury without, as the New York Times points out, quote, presenting a smoking gun that clearly shows that to be the case. And just in the last hour, prosecutor Joshua Steinglass got to work in addressing and doing any cleanup he thought necessary on these questions around Cohen's credibility. Steinglass telling the jury this, quote, we didn't choose Michael Cohen. We didn't pick him up at the witness store. Mr. Trump chose Mr. Cohen for the same qualities his attorneys now urge you to reject. Whew. Noticeably missing from the defense's arguments this morning, any and all pushback against that wealth of documentary and circumstantial evidence, all of it corroborating Cohen's testimony before he ever took the stand. Blanche, on that front, claimed that there wasn't a shred of evidence regarding the Trump Tower meeting where the repayment scheme was hatched. That is not true. Blanche ignored in his close the handwritten notes entered into evidence from Alan Weisselberg that showed exactly how the $420,000 reimbursement payment was added up. Blanche, Trump's lawyer, also made a bold claim. He said today in front of the jury that plan for the National Enquirer to catch and kill negative stories about Donald Trump ahead of an American presidential election was totally normal. Basically, everybody does it, that it was above board. Blanche arguing, quote, every campaign is a conspiracy to promote a candidate. To that, prosecutor Joshua Steinglass called the agreement at Trump Tower where the plan was hatched a, quote, subversion of democracy, arguing that the whole point of the scheme was to, quote, pull the wool over voters' eyes. Blanche did not finish his closing this morning without doing something that earned perhaps the sharpest rebuke of this 5-week trial from the normally very even-keeled Judge Juan Merchan. Blanche, in his close, said this to the jury, quote, you cannot send someone to prison, based on the words of Michael Cohen. Prosecutors objected immediately, and Judge Merchan said this, quote, I think that statement was outrageous, Mr. Blanche. It's simply not allowed, period. It is hard for me to imagine how that was accidental in any way. So then the jury went out after that happened. And later, when they came back in, the judge corrected Blanche in front of the jury, telling the jury explicitly that a prison sentence is not required in this case. And on Blanche's comment, the judge added this, quote, that comment is improper and you must disregard it. The prosecution's still underway and getting its final chance to hammer home the case against Donald Trump. It's happening at this moment, and it's where we start today with some of our most favorite reporters and friends. They've all made their way from inside the courtroom, which was very warm today, up to our very climate-controlled studio. For that, we're grateful. With us at the table for the hour, MSNBC legal analyst Andrew Weissmann is back. New York Times investigative reporter Suzanne Craig is back, and former executive editor with American Media Inc. and special correspondent for The Hollywood Reporter Lachlan Cartwright is back as well. Outside the courthouse for us, NBC News correspondent Vaughn Hilliard. Vaughn, let's start with what's happening right now, and then why don't you and I work our way back to this Merchan rebuke?
Right, Nicole. The jury just re-entered the courtroom. Now, on a typical day at 4:30 p.m. Eastern is when court has ended. Everybody has been sent home. But earlier in the day, Judge Merchan made it clear that they would try to get through both sides' closing arguments by the end of today, essentially so the jurors could hear it in one major chunk. But now you're looking at a reality that just a few minutes ago, there was a break that was announced. The jury left the room, and the prosecution, about an hour and 45 minutes into their closing arguments, were just asked by Judge Merchan how much more time do they have. They said they were just about 1/3 of the way done. So if you do the math, that could take us to about 8 p.m. Eastern if the time moves based off of their clock. Now, the defense, they went for about 3 hours this morning as part of their closing arguments. And when you compare the two sides, you can look at the defense. It was a rather simplistic, effort and contention that was made to this jury. It was twofold. Number one, Michael Cohen is a liar. More than 45 times I counted that Todd Blanche either called Michael Cohen a liar or said that he had lied. And then they are also trying to cast doubt, a reasonable doubt in the minds of these jurors that Donald Trump was intimately aware of the scheme and what he was paying Michael Cohen for. On the other side of this, the prosecution, it's much more methodical. And that's why you could be looking at their closing arguments lasting anywhere, by their own math, 5 to 6 hours, because it is on them to make the case to this jury that Donald Trump was not only intimately aware, but behind the conspiracy that went from August of 2015 all the way through 2018.
Andrew Weissman, to Vaughn's great reporting, they're going to take a break in about an hour at 5 o'clock. Judge Merchan's going to ask the jurors how they're doing, if they want to keep going or if they want to take a break.
Right. I mean, I'm pretty sure that the prosecution would like them to come back tomorrow, just so they're fresh. It is. It is a long day to sit there and take in all that information, and you want them to be fresh from both sides, so they're hearing it. So, I'm sure Josh Steinglass is ready. I mean, in other words, he's got everything buttoned down. It's really very smooth. But in terms of what I think the state would want, I would think they'd want to take a break. But it's pretty clear from when we were there that Judge Merchan is going to leave it totally to the jurors and say, he left it. He's so even-keeled, as you pointed out. He just said, it's whatever you want. If you want to stay, we'll do that. And then but he also said, you want to come back tomorrow, we'll do that too.
Right.
With not trying to put a thumb on the scale. It's like, whatever you want, that's what we're going to do.
And, I mean, who would you argue it benefits if you come back in the morning?
I think it benefits the state it's not that they need the time to prepare. It's just, again, you just
get a fresher jury, get a clean page in the notepad.
It's like if you go to a museum, at some point you're like, I can't see it anymore.
That's me after 10 minutes. Yes.
Okay, some 10 minutes, some an hour, but that's a lot of time to be processing and having all of that incoming.
So then, Craig, what's in your notebook? I want to work our way backwards because I want to bring our audience into what's happening right now. And what's happening right now is what the hallmark of the state's case has been precision, but also a nimbleness, an ability to adapt to what the defense is putting before the jury and the judge. And they seem to have adapted to what Blanche did this morning.
Right. I think they've pivoted. I mean, and Josh Steinglass got up. It was interesting. We were talking about it. We take the subway from court up here every day, so we get a good chat session. And we were talking about Josh Steinglass's closing and how he started. It felt quite abrupt. It was interesting because he right away made a decision to address some of the things that Donald Trump's lawyers had brought up, some of the things about Michael Cohen's credibility. There was a great moment about the call. I thought that was one of the best moments that we saw, where there's that call that's in question where Michael Cohen calls Keith Schiller. And is it about the harassing phone calls that Michael Cohen had been getting from a 14-year-old, or was it something to do with Stormy Daniels? And Josh Steinglass actually in that, he made up he kind of role-played the call and fit it in, I think, into 92 seconds. So he, at the beginning, it did feel a bit abrupt, but he decided to address some of these things right away. But I think that the main thing that came out of this morning, when you distill it all, there was some issues, where Donald Trump's lawyers looked first at that the payments were legal. That was one of their first things. But the main thing that they did was go after Michael Cohen over and over and over. They called him, the the gloat, greatest liar of all time. And they just kept hammering home that he is a liar and that you can't believe anything he said. I think that was sort of the underpinning. Some of their stuff, I thought, though, it was weak. There was the, they started out, and in a vacuum, it felt like a smart idea to argue that these were payments for legal services. But then they put on the screen the now famous exhibit. Is it Exhibit 35?
35
yeah,
36.
where we've got the gross up, where Alan Weiselberg grosses it up, and then they go in, and Donald Trump apparently signed off on it. Michael Cohen takes it to him, and they're saying that's for legal services, but it's done on a page it's the wire transfer to for the Stormy Daniels payment. Come on. And I wouldn't have put it up in the first instance, but I wouldn't have let it linger there. If the jury had forgotten it was on the paper that, was the wire transfer, they remembered it this morning. It was just another reminder. And it really did defy common sense. I mean, when you're looking at it, it's not for legal services, it's on that paper.
We are wrapping our part of our special recap of today's closing arguments in Trump's criminal trial. But do not go anywhere. Our coverage continues with The Last Word and Lawrence O'Donnell, who spent today in court and has the back pain to prove it. Good evening, my friend. Good evening.
I was working on my posture for most of the day, Rachel, in that chair. But look, Rachel, two full reporter's notebooks today. I've never filled up two in a day before, I think. Certainly not a courtroom day. It went on longer than any of us expected. I think longer than most of us thought was necessary. But, it was one of those no stone unturned closings by the prosecution. The defense, I thought, was as effective as they could be given the cards that have been dealt them. They've got some internal contradictions in their theory of the case. But remember, this is a criminal defense team trying to defend Donald Trump. Yeah. Good luck with that. It's going to look pretty messy.
Judge Merchan said at the outset that it is his practice as a matter of running his courtroom. He likes for the jury to get both summations on one day. And I felt like heading into today, I was so worried about whether or not there would be other trailing ends from the trial, which sort of ended on the schedule he didn't want last week, and whether they'd be able to squeeze them in. I was thinking each summation would be like 90 minutes. When we got 3 hours, and that was the short one, and then 4 hours and 40 minutes as the second one, I mean, it really was an endurance test for the jury. But the judge, who seems to be very bonded with this jury, does seem to think that it is in their best interest that they got them both today, that they didn't have a break, and that when they come back fresh tomorrow, they are just looking at him and listening to him and then getting to work.
Yeah, and the judge did say, when this thing was well into overtime, that he has been, after the jury left for a recess, he told the lawyers, I've been watching the jury. They still seem to be with us. They still seem to be ready to keep going. And of course, the jury wants to go. They want to get this job done and have it be over with as soon as is reasonably possible for them. And so the judge had already said to them, listen, we might need to go late on Tuesday night. They were warned about that a week ago, so they were ready to go late tonight. And but boy, when we heard the prosecutor say that he maybe had 4 hours of material, I have to say it felt like, we're going to be here tomorrow morning finishing the final summation here. But the judge really didn't want that to happen. And Rachel, just to show you, the judge does have limits to his patience. This is one of those things that you had to kind of be in the courtroom for. In the last, 10 minutes or so of Josh Steinglass's summation that the judge clearly was finished with. Like, this really should be over. There was a moment where there was an objection, Todd Blanchard objection. It was sustained, understandable objection, sustained. And then the prosecutor said, may we approach? Now, every single time that either lawyer said, may we approach in this trial, every single time, they approached the bench and had a bench conference. This time, in the fourth hour of the DA's summation, when he said to the judge, may we approach, there's no word in the transcript because it's just the judge shaking his head no. Just no. Just
talk
no.
to the hand.
Nope, don't approach. Don't even think about approaching.
That's fantastic.
You should approach the exit, is what the judge was letting him know.
I know you need to start your portion of the recap, and this is rude of me to do, but can I ask you one more question about your experience in the courtroom? You have been in the court a bunch of days, and not just in the overflow room, but in the courtroom itself. Do you have a vibe from the jury in terms of what you think, how you think the jury is behaving, whether there might be a holdout or two juror who really isn't paying attention, who might not be there in good faith? Do you feel like the jury is doing a good jury job?
You know, I'm so glad you asked that, because that's exactly how I was about to begin this discussion here.
Okay.
There is, by the way, nothing in the teleprompter tonight. I haven't had a time to write a single word rushing from the courthouse up here. But this is exactly how I wanted to begin, and I'm glad to begin it with you, because I do believe that I've now heard all of the testimony. I've heard every word of the summations. And hearing every word of the summations is maybe the most important thing you can do. If you could pick one day to be there, that would be the day. And so what I can tell the audience, and I can tell you, is I've been in a lot of courtrooms over the course of my life. I've heard a lot of testimony. I've had strong feelings about possible verdicts at the end of summations. I've certainly had strong feelings about what the obvious and correct verdict is, and only some kind of jury bias can derail this. This is one where I don't have any idea. I'm coming out of this with no ability to read this jury at all. I had a great, this afternoon, I had one of the best views of the jury I've had of the entire trial. By the way, in that courtroom, no one has a good view of every juror. That's impossible in the way the courtroom is laid out. Sometimes you'll have a better view of the back row of jurors if you're on the right side of the room. Other angles have other views of jurors. I've seen all of these jurors at different times and studied them all as much as I could. I can't find anything from any of them, and I offer them that as praise, because that's what they should be delivering to me and to everyone else in the courtroom. They should be delivering nothing except their attention where their attention is merited, whether it's the witness stand or the attorney's podium, as it was today. And they are just fully and constantly attentive, more so than any jury I've ever seen. You don't see a moment of them drifting off at any point, even at the times when some of us in the audience might drift off a bit because it might feel like we're going down a tangent. That jury is so attentive and so on point all the way through. And they've never given me the slightest hint, and I haven't heard from anyone else, anybody getting hints about how this jury is feeling. I think that the defense did everything they could do today and throughout the trial to introduce reasonable doubt. And it's always a question of, is that enough reasonable doubt that the defense has introduced for enough jurors? Is it enough reasonable doubt for one juror? Is it enough for 12? I don't know. Did the prosecution present its case beyond a reasonable doubt? I think that could be a very clear and relatively easy finding for this jury. But I come out of it able to tell you, Rachel, I have no idea which way this verdict is going to come out. I won't be surprised by any version of this verdict.
It's fascinating to hear you say that, and I'm glad you've taken the time to do it. I'm sorry to be taking over your hour by making you do this with me, but we're starting to see the first reporting now that is attributing, confidence or hope or worry about jurors to one side or the other in the case, and it feels like wishful thinking and projection by, in this case, the Trump side, than it does more than by anything that seems actually observable in the courtroom. And I feel like that's a good reality check for all of us, that there's nothing, and it was my experience as well being there a couple of days, there's nothing that this jury has done to tell you what they are going to, how they are going to deliberate, or whether any of them is going to act in a bad faith way and force a hung jury when one isn't deserved. And at this point, it really is in the jurors' hands, and this judge has treated them with respect, and they've treated the process with respect, and that's how it's supposed to go.
Yeah, that's absolutely the case. For me, most of the time, in most of the trials I've seen, jury guesswork has been a complete waste of time.
Yeah.
I have wasted none of my time on that subject in that courtroom.
Right on, Lawrence. Thank you, my friend. Much appreciated. I hope you get some important ibuprofen in your future.
I'm going to need it. Thanks, Rachel.
Thank you, Lawrence.
Thank you.